Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the Western Canada practice leader. Thank you for joining us today. We are here today to answer any and all questions you have related to your employment rights. I'll be answering questions related to the employment law of BC, Alberta, and Ontario. So if you're in any of those provinces and have some questions about what your employment rights are, feel free to put them in the chat. We are going to try to answer as many of them as we can in the next half hour. So go ahead and put those questions in there. I suspect I'll be getting a lot of questions about the recently announced tariffs from the United States on steel and aluminum products and what that means for people impacted by that. So, of course, tariffs are never a good thing for employment. They oftentimes lead to reductions in sales and reductions in production and potentially layoffs or terminations. So definitely something that a lot of people are concerned about. What I can tell you from an employment law perspective is if an employer is telling you, well, I have to cut your pay now because of these tariffs, or I have to lay you off because of these tariffs, or I have to let you go, you still have rights. All right, those rights aren't suspended just because we're in a situation where there's tariffs or even potentially a trade war. You still have rights, and those rights include that there can't be drastic changes to your employment conditions without your consent. You can't be laid off without your consent, and if you are terminated, you're owed to your full severance. That doesn't change just because the economic climate is looking a little darker. All right. So if that's happening to you, if your employer is saying, listen, you got to take a pay cut, you got to go down to 4 days a week, something like that, feel free to reach out to you. Feel free to reach out to us, and we'll be happy to help you navigate that situation. So if you're looking to get in touch with us, you have the website right there on the screen, employmentlawyer.ca. That's the best way to reach us, employmentlawyer.ca. You'll get in touch with one of us, and we'll be able to help you navigate these turbulent waters. So we have our first question coming in from John Q. John is asking, if a manager starts requiring monthly timesheets after a couple of years of never having to do them before, is that allowed? Salary position UA. I'm not sure what UA stands for, but essentially, what I can tell you about timesheets and things of that nature is whether it's allowed or not allowed really depends on whether it's such a substantial change that your employer is required to get your consent to it. All right. So when we're talking about substantial changes to your employment, we're talking about, drastic reductions in compensation. I'm talking about 15% reduction in compensation or more, reductions to your work hours of an equivalent amount or more. So reductions in hours of 15% or more is probably, your consent is required. Layoffs, demotions, things like that. So whether they're asking you now to fill out timesheets to get paid, at first blush, it doesn't look like it's such a substantial change that your consent would be required. It looks like they're just kind of updating their payroll policies or what have you. It could be potentially that you view this as a substantial change for whatever reason. If you can show it to me or show it to your employer, this is a substantial change, then they would have to obtain your consent. But if it isn't a substantial change, your employer is given a lot of latitude in the law to organize their business as they see fit, right? So if they want you to fill out timesheets this week and last week they didn't require that, then that unfortunately becomes what you have to do. You kind of have to follow your employer's direction on something like that. But if for some reason that is a substantial change, and you have a reason why, maybe they're trying to set you up for some sort of disciplinary action or something. They suspect you're not doing your full hours or something, but you've been working the same way throughout the last 2 years. Maybe that could be something, but I'm just kind of hypothesizing. If it's just, no, we just want everyone to do timesheets just for our record keeping, then I struggle to see how that would be anything that they would require your consent. And of course, if it is a substantial change and you don't consent to the change, then it becomes a question of it being a constructive dismissal. You have the right to say, I'm not accepting this change. If you decide to impose it on the employer, knowing I don't consent to it, I will treat it as a termination and pursue my severance. I'll treat this as a constructive dismissal. So those are your options. There's no way for a judge or anyone in the legal system will say, no employer, you can't reduce, hours by 15%. They'll say, well, you did that. That wasn't accepted. Now you owe the employee their full severance. They won't say, now you have to continue to pay the employee what they were being paid before. One of those issues where you have to be ready to quit and pursue your severance. All right, we have another question coming in from Mackenzie Bowker. Mackenzie asks, hello, my boyfriend had vacation that was approved back in October. Now his employer is saying he is not able to take that vacation. Is he still entitled to that vacation time? So essentially, vacation generally has to be agreed to by the employer and the employee as to the time of the vacation. So if that was approved back in October, as you say, then it's very frustrating that your employer has changed their mind. And there might be consequences to that. If you've booked, a trip, flights, hotels, or something like that, that might end up with you holding the bag there on having to claim some refunds that might not be forthcoming. In terms of vacation time, if your employer cancels your vacation, doesn't mean that you're not owed vacation. All right, that vacation time can be used at another time. But if there is a situation where you have to take this vacation time now, I can tell you, if you take your vacation, even in the face of your employer telling you that you can't, that could amount to misconduct, justifying discipline. So tread carefully there. I would say try to go talk to your employer and see if something can be worked out, either that they refund you for some of the income that you're losing for these cancellations, or maybe arranging some sort of coverage so that you can take your vacation as previously scheduled. Because generally, if the employer doesn't consent to you taking vacation time at a certain time, and you still take it, that can amount to misconduct, and that can result in some form of discipline, up to and including termination. So tread carefully. If you really do need a bit more tailored help on how to navigate this issue, and you want to explain to us exactly what are the consequences of this vacation being moved, because I'm not exactly sure what the challenge is with moving it. I'm sure there is some, but I'd like to have a better idea. Reach out to us. We're at employmentlawyer.ca. Employmentlawyer.ca, that's the website. We have another question coming in from YouTube from Dean Whitty. Dean asks, are volunteer firefighters, which is a paid position, eligible for severance if they are terminated without cause? How would it be calculated, as the wages vary from year to year? So generally, all employees are entitled to severance, unless there is some law that says no, these kinds of employees are not entitled to severance. I'm not aware of any for volunteer firefighters. I don't know if this is a unionized position that you have. Of course, unionized positions, severance entitlements might be explained in the collective agreement. So that's where I'd refer you to your union rep. But otherwise, then you would be entitled to severance if you're terminated on a without cause basis. So essentially, to understand how much severance you might be entitled to, we have a great tool that we use, that we offer to the public, called the Severance Pay Calculator. You can access the severance pay calculator at employmentlawyer.ca right there on the screen. Pocketemploymentlawyer.ca right there on the screen. And we ask you 4 easy questions that'll allow us to estimate how much severance you're owing. Those are going to be your age, your length of service, the type of position that you held, and how much you earned. All right. So the question you're now having is, well, how much I earned kind of varies from year to year depending on different circumstances. That's kind of where it gets tricky. What we're trying to estimate is what you would have earned during your severance period. So if we tell you, you can be owed up to 24 months of severance. If you're owed 24 months of severance, how much do we expect you would have earned during that 24 months had you stayed in the job? So it's an imperfect science. But essentially, if we look at the start of your career, you weren't earning much, and it's been progressively increasing, and we'd use the last year, for instance, because that's a better indication of where your income was headed than perhaps your first year. If it's really a seesaw kind of situation where the numbers go up and down without any real rhyme or reason from year to year, then we usually would probably consider averages, probably a 3-year average, to estimate how much income you would earn during your severance period. So that's kind of how we do it. It's kind of hard to predict. You might say, well, actually, it's been kind of seesaw over the last 3 years, but the next 2 years I expect it to be very busy. We've got wildfire seasons have been pretty strong, and I mean wildfires or there's a lot more home construction, and those tend to end up with more fires. If you can kind of explain why it should be that it's going to be higher than the 3-year average, then we'll definitely be open to hearing that and considering that in our estimates. But that's basically what we're trying to show. What would you have earned during the severance period had you stayed in the job? So you might have an idea of what that could have been based on past trends, and we might develop an idea ourselves once we're looking at your income from the previous years. So try to use that Pocket Employment Lawyer. The severance pay calculator is a very nifty tool. It'll give you an estimate of what you may be entitled to if you're terminated. And it's often in the tens, if not hundreds of thousands of dollars. So it's an important financial decision when you're being terminated. Do I accept the first offer made by my employer? Do I reach out to a lawyer and see how much I may be entitled to? Tens, if not hundreds of thousands of dollars, ride on that decision. So treat it with the importance it has. Treat it as an important financial decision. You buy a home, you look at getting some advice, do your taxes, buy a car. You look around, you try to make a good, well-informed decision. The same thing happens when you're terminated and you're being presented with a severance package. You have to look into it, make sure that what you're getting is fair for you. All right. So we have another question coming in from Miguel from YouTube. Last week, I was talking with some of my colleagues about some issues that have been around at my workplace involving our regional manager. Everyone shared their position, including me. 2 days later, someone close to my boss told me he heard our conversation and was upset. He then cut my work hours from 45 to 20. Is this even legal for him to record private conversations without previous consent? So Miguel, whether it's legal, probably depends a little bit on which province you're in between BC, Alberta, and Ontario. It's most illegal in BC and Alberta where there are privacy laws. There aren't the same privacy laws in Ontario, so it's theoretically a little bit more debatable, but generally, no. Yeah, you shouldn't be recording conversations that you're not part of. So if it really was your employer somehow had a recording device in the break room or wherever where you guys were having your discussion, it's likely not legal. And that conversation would likely not be allowed into court. All right. But the more important issue here is that your hours have been cut from 45 to 20 hours a week. All right. So that, as I was saying earlier in the show, a substantial reduction in your hours can amount to a constructive dismissal. A constructive dismissal is whereby you say, well, listen, you've cut my hours by more than half. I can't afford to live on the money I'm now making. So you've essentially terminated me without using the words because you're forcing me to quit, right? So I am going to quit. And because it's you that forced me to quit, you're going to have to pay me my severance, all right? You're going to have to pay me my full severance because you brought this upon yourself, all right? So looks to me like this is a pretty clear-cut case of constructive dismissal, Miguel. So feel free to reach out to us, and we will speak to you about what your severance entitlements might be and how to go about getting them, all right? So reach out to us. Employmentlawyer.ca is how you reach out to us, and we'll be happy to help you understand what your severance entitlements are and how to go about getting them, all right? We have another question coming in from S. Barton. S. Barton asks, what should you do if your employer has eliminated your position while off on medical leave? We actually get this question quite a bit, S. Barton, and there's two things that happen. So firstly, if your position is eliminated, that is often going to be a without cause termination, all right? Which means that you're owed severance, okay? And that severance is the same whether you were employed at the time the position was eliminated or whether you were on medical leave at the time that position was eliminated, all right? You're owed the same amount of severance. So that's if the position was eliminated while you were on leave, but the leave had nothing to do with it. So you can imagine a scenario, a department gets shut down, it's everyone in the department is made redundant, and one of those people happens to be on medical leave. That person is also made redundant. So it's not because that person was on medical leave that they were terminated. It just so happened they were on medical leave when they were terminated. So that person is entitled to the same amount of severance they would have received had they been employed at the time they were made redundant. But what we often see are situations where the employer doesn't want that person that's on medical leave to go back, so they terminate them and say that it's because of a redundancy or something like that. Now, it's up to the employer to prove that, because if the reason the position was eliminated is because that person was on medical leave, then that amounts to discrimination under human rights legislation. There's probably also a violation of employment standards legislation. So not only would you be owed your severance, but you might be entitled to human rights damages, lost wages, reinstatement. So a lot of new options present to you if you were terminated because you were on medical leave. And it doesn't even have to be the only reason. So long as one of the reasons why that position was eliminated or why you were terminated was because you were on medical leave, then that amounts to discrimination. All right. So again, something that you might not know the inner workings of the decision-making process that led to your termination. You just know you were on leave and you were terminated while on leave. We can help gather that information and help you pursue your entitlements, your full range of legal entitlements. So once again, if you're listening, feel free to reach out to us. We're at employmentlawyer.ca. Employmentlawyer.ca is how you get in touch with us. You have the website right there on the screen. And for those of you who joined late, my name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru, Tumarkin, LLP. I'm also the Western Canada Regional Practice Leader for Employment Law. We're here to answer your employment law questions up until 2 p.m. Mountain Time. We got about 12 minutes left, so keep those questions coming. We're going to try and get through as many of them as we can before the end of the show. We have another question coming in from Attila43. Attila43 asks, my partner is being placed on a PIP for being late recently due to the weather we have had. Can he be let go for cause because of this? Okay, so for those of you who don't know, a PIP is a performance improvement plan. So what I understand from what Attila 43 is saying is their partner was late to work and was put on a performance improvement plan. What that generally means is that their performance will be monitored for the next 3 months, and they will have certain criteria they have to meet, certain performance objectives they have to meet. So for instance, a performance objective of not being late to work. All right. So Attila 43, employers can potentially terminate someone for chronic tardiness. They're going to have trouble doing that if there's one instance of tardiness and it's related to a weather event. All right. So I know across Canada we've been having weather events this winter, and of course it results, in more traffic, road closures, etc. Right. So it's kind of expected that some people will end up being late because of that. So if really this is the first time your partner has been late, then I think that's really out of line. If this was a culminating event and there's a pattern of tardiness, and this might start to become an issue with the employer. They might not have chose the right or the perfect occasion to put in the PIP, but they're trying to correct some behavior. All right. So essentially, it's important that your partner take the PIP seriously, because the end result of the PIP is either he'll graduate out of the performance improvement plan, he'll pass essentially, or he'll fail the performance improvement plan, which does set up a potential termination for cause. And if you're terminated for cause, as you know, you're not entitled to any severance. Now, employers also tend to use PIPs a little bit like a silver bullet, that so long as they put up some criterias and you don't meet them, they can terminate you for cause. It's the standards that they're imposing on you have to be realistic, frankly. And so if it is seeming like your partner is in the process of failing the PIP, then reach out to us sooner rather than later at employmentlawyer.ca, so that we can kind of ensure that his rights are protected. I've seen PIPs, for instance, for salespeople where they introduce, someone might not be reaching the sales target, but then they put new targets that are above the sales targets for everybody else. So that's not a reasonable target, especially if someone is not meeting the agreed to sales target. So they might have, a policy, for instance, that everyone has to be at work within 5 minutes of their start time, but they're telling your partner, well, no, you have to be there right at 9 a.m., right? No more excuses or stuff like that. So that's how these policies can end up being unreasonable. And frankly, if the policy doesn't account for the fact that sometimes stuff happens, then that can make it unreasonable as well. So if your partner is late, again, because of certain issues that are outside of their control, it's important that they explain that right off the bat to their employer. Listen, I'm late, but for reasons beyond my control, the highway was closed because of an accident or something like that. You have to explain that. And frankly, if something like that were to happen and your partner is going to be late by an hour or so, as soon as they realize that they're going to be late, rather than wait till they get to work to let the employer know, is to see if they can contact the employer and give them some notice, even if it's a half hour's notice, better than nothing. It goes to show that your partner is taking the process seriously. But if it is getting kind of dicey and it looks like they're trying to set them up to terminate them without cause, reach out to us, employmentlawyer.ca. Right? I've seen so many employers use PIPs inappropriately, and we've had a lot of success getting employees who were allegedly terminated for cause, getting them their severance. So don't think that it's a silver bullet, that just because your partner's on a PIP that there's no recourse anymore. There's plenty of recourse. All right, we have a question coming in from Reddit from Carol. Carol asks, I was sent home from the company that I've worked for the last 7 years. They have promised this is a temporary layoff. The record of employment they issue says I have been terminated. How do I apply for my severance pay in this present situation? So layoffs can amount to a constructive dismissal. All right. So a lot of employees might not be aware of this, but an employer cannot lay you off without your consent. Okay. If an employer lays you off unilaterally without even asking you your consent, you can say, well, listen, I am here to work and to earn compensation. If you're not going to provide me with work and compensation, then I'm going to treat that as a termination and pursue my severance entitlements. All right. So there are exceptions to that, but I'll explain those very quickly. If you are laid off for the first time, all right, you can treat that layoff as a termination. If you've been laid off in the past, been recalled, went back to work, and now are laid off again, there's a past practice of layoffs, so it's going to be harder for you to claim that you don't consent to the layoff. All right. There are also people who have written employment contracts, and the employment contract will say that the employer has the right to lay you off, and because you signed that employment contract to start working, you've consented to being laid off. So unless there's something in your employment contract saying that you can be laid off, or there's a past practice of layoffs, The first time you're laid off, you can treat that as a termination and you can pursue your severance. Okay. So if the employer is saying, no, we're going to recall you, we're not going to pay you severance, call us. We'll explain what I just explained to you. We'll explain to the employer, and the employer will come around and pay you your severance. So if you're in that situation where it's your first layoff, Carol, and there's nothing in your employment contract says they're allowed to lay you off, reach out to us, employmentlawyer.ca. This is a question we're going to get a lot more of, given these tariffs, given this current economic crisis climate that we're in. It's important that you realize you have options if you're being laid off. All right, so reach out to us if you're being laid off. Employmentlawyer.ca. All right, we have time for one last question coming in from Smokey on Reddit. Smokey is asking, I am a seasonal worker and have been with a snow removal company for the last few years. My employer did not contact me to start the new season of work, and he's been ignoring my calls and emails. Can I consider this a termination and apply for EI still? Am I entitled to any sort of severance? So regarding the EI claim, I couldn't tell you with precision, Smokey. You would have to contact EIs directly, Service Canada in essence, and ask them if you can apply, whether you have enough insurable hours and all of that. Now, a lot of seasonal workers come to us and they say, well, listen, I expected to be laid off for the season, but I also expected to be recalled, and now I'm not being recalled at the end of the season. What are my rights? Well, your rights is if you've been, if there's been a pattern of you being laid off for the off season and then recalled, there's been a pattern of a few years of that happening. It's become the understanding between the parties that yes, there is a seasonal layoff, but you have continuous employment otherwise, right? And so you would be owed severance if you're not recalled at the end of the off season, which is what happens to you, Smokey. So yes, you would have entitlements to severance in this case. All right. So basically, we would look at the amount of years that you've been in the with this snow removal company, and calculate your severance based on that. So if you're looking to see how much severance you might be owed, Smokey, you can, as I said earlier in the show, you can visit our severance pay calculator. To access our severance pay calculator, it's at pocketemploymentlawyer.ca. You have the website on the screen. It's a great tool. All we ask is 4 easy questions that anyone can answer, which are your age, your length of service, the title or position that you held, and how much you earn. All right, and from there we'll be able to estimate how much severance you're owed. All right, and no obligation, and just so you have that information. A lot of our viewers come to the show and say, "Oh yes, I'm entitled to severance," but don't really understand how much we're talking about. It can be a lot of money. So very important you do your due diligence, find out what you're owed if you're potentially terminated, or as in Smokey's case, if you have been terminated. So find that out, and if you do want to reach out to speak to one of us, then we're a click of a button away. All right. Attila43 says, thank you. You said you are located in Alberta. I will have him call you. Well, absolutely, Attila. Thank you for your kind words. I am in Alberta. We have an office here in Alberta in Calgary. We'll be happy to speak to your partner if he's going through that problem with his performance improvement plan. All right. You can also reach out to us at employmentlawyer.ca, if you want to reach out to us that way. All right. Well, that's the time we had for today. Some great questions once again, really good questions. We have our next show tomorrow at 1 p.m. Mountain Time with my colleague Karen Taraposky. She'll be here to answer any questions I wasn't able to answer for you today. She will answer for you tomorrow. So feel free to join. Once again, my name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm the Western Canada Employment Practice Leader, and it was my pleasure to speak with you today. I hope you have a nice rest of the day.